Welcome everybody to the Bankruptcy Options, Bankruptcy Basics webinar today. Thanks for attending. I have a little bit of a cold, so hopefully my voice will hold out, but I'm glad you're here to learn about your bankruptcy options. So let's get rolling. My name is Jesse Aschenberg. I'm the managing attorney for the bankruptcy law professionals in Colorado. I have been practicing law for about 15 years and have been doing primarily bankruptcies, what we call consumer bankruptcies for that time. Consumer bankruptcies are business bankruptcies for individuals and families, not the large corporations. So some contact information is there on that first screen. So let's just jump in here and get rolling. First question to answer is, what is bankruptcy? So bankruptcy is a legal proceeding, and it's in federal court. During my years of practice, a lot of my clients have thought it was in state court or county court. So I'm in Arapahoe County, and some of my clients thought they could go down to the Arapahoe County courthouse and file bankruptcy, and they cannot. They could file bankruptcy with the federal courthouse in Denver. There's only one bankruptcy court in the state, and that's the Colorado Bankruptcy Court. Bankruptcy also immediately stops your creditors from seeking to collect debts from you, at least until your debts are sorted out according to law, and we'll touch more on that in a minute here. Who are the players in a bankruptcy case? Well, it's pretty straightforward. There's really three players. There is, let's see if I can grab a little highlighter here. There is the debtor, that would be you, listening to this webinar, the person who owes the money. Then there's somebody called the bankruptcy trustee. The bankruptcy trustee is another attorney who works as a fiduciary for your creditors. Their job is to interview you and make sure that the information you provided to the bankruptcy court is true and accurate. They're also there to collect and disperse any funds, if there are any, to give to your creditors. And then with any good judicial proceeding, there's the bankruptcy judge. Here in Colorado, we have 5 of them. Usually in a Chapter 7 case, you would never see a bankruptcy judge. In a Chapter 13 case, you might. They are involved in every case, although you don't typically appear as a debtor in front of a judge unless there's a hotly contested issue, which is fairly rare. Moving on here, a little bit more about the players. So as far as players are, there are the debtors and their lawyer. So I am a debtor's lawyer. Then there's the bankruptcy trustees that we talked about. There's the bankruptcy judge. And then there's your creditors. And there are 3 types of creditors in bankruptcy. They are what we call priority creditors. Those are basically taxes and child support. There are secured creditors, which are mortgages, car loans, homeowners associations, judgment liens, tax liens, things like that. Creditors that have a security interest in property. And then there's your unsecured creditors, which are everybody else. Your medical bills, some taxes, payday loans, so credit cards, credit cards for sure, student loans. Okay, so those are the basic players. Next slide. Statistically in bankruptcy, 80% of all bankruptcies are Chapter 7. So most of what I'll talk about today deals with Chapter 7 cases because that's the majority of the cases. And it has been really for a while. 19%-ish of bankruptcies in Colorado are Chapter 13, so I'll cover more in detail with those out here later. And then 1% are Chapter 11s. And Chapter 11s are large corporations. For example, Sports Authority just filed for bankruptcy. They are in Chapter 11. And who else is in Chapter 11? There's not one off the top of my head, but Chapter 11s are larger corporate bankruptcy cases that you see. They're also the ones that make the news because they affect a lot of people. So, what debts are forgiven in bankruptcy is a really important question. It's more easy to say what debts don't go away in a bankruptcy case than what debts do, because the number of debts that do go away in a bankruptcy case are so much more than the debts that don't go away. So let's just cover the debts that do not go away. First of all, most taxes do not go away in a bankruptcy case. Taxes can be forgiven in bankruptcy. It's very technical. I certainly have the ability to assess that, but in general, Those taxes do not go away in a bankruptcy case. Student loans are not dischargeable in bankruptcy, much to my chagrin. You're stuck with those for now in a bankruptcy case. Maybe that'll change in the future, but that's how they are now. Child support, alimony, if you've gone through a divorce or you've had children and child support of any kind, if you owe back child support or you owe past due alimony or maintenance, then that is something that does not go away in the bankruptcy case. Fines and fees. It says here fines or criminal restitution. Fines, a good example as I put on the screen there is DUI cases. If you've had a DUI, those can range up to $10,000 between fees and costs and probation fees, etc. That's not something you can put in a bankruptcy case. Parking tickets are not something you can put in a bankruptcy case. E470 tickets are not something you can put in a bankruptcy case. Maybe more clear on that. I would list them in your bankruptcy case. I would notify the person who you owe money to that you filed for bankruptcy, but technically those obligations do not go away after a bankruptcy case is filed. Then there's fraud. Fraud is not dischargeable. A fraud claim has to be brought by a creditor saying that you've committed fraud on them, and therefore the debt is not forgivable in a bankruptcy case. A common example of fraud would be racking up a bunch of credit card debt right before you file a bankruptcy. And by a bunch, I mean over $700, $800 on one card, and then filing for bankruptcy on that card within just a few months of racking up that debt. Another example, well, I had a client of mine who was a realtor, and he was smart enough and had done his homework on bankruptcy enough to know his options. So he went out and he discovered that he had $15,000 on his credit card available to him in cash. So before filing for bankruptcy, he took out that $15,000 in cash on his credit card and put it under his mattress. And then he filed bankruptcy, and of course the credit card company said, hang on a second, that's a lot of dough, and that's done too close to the bankruptcy case. So they brought a fraud claim against him. In most bankruptcy cases, fraud is not an issue, but we always look for it, because if it is an issue, we need to know up front so we can plan for it and strategize about it, and at least cancel compliance about it. Then there's things called reaffirmed debts. And reaffirmed debts are debts that are dischargeable in a bankruptcy, so they are not taxes, they're not student loans, not back child support, fines or fees, and they're debts that you want to still remain obligated to after the bankruptcy case is done. A common example would be a mortgage or a car loan. And so a reaffirmed debt is a debt that you listed in the bankruptcy case, but then by filing appropriate paperwork with the bankruptcy court, you then removed it from the bankruptcy case, so the debt is not included in the bankruptcy. Reaffirmed debts. Those can be addressed more specifically depending on the person's case and the needs of that case. Next slide. What stuff can I keep? That's a very important question in the bankruptcy case. Spotlight here back. So, in bankruptcy, if you have a house, and the house is your residence, you can have up to $75,000 of equity in your residence and file a bankruptcy case. That's net equity after realtor's fees and other costs of sale. That's if you're below 60 years old. If you're 60 years old or older or disabled, then you can have up to $105,000 of net equity in your house and file a bankruptcy case. So at this time, we're now March of 2016, house values in the Denver area are skyrocketing, so this is always an issue I look at when somebody comes to me for bankruptcy and they have a house that they own. This equity does not apply to any rental properties or investment properties. It does not apply to timeshares. It only applies to a house you live in. So motor vehicles is another important issue. In bankruptcy in Colorado, you can have $7,500 per debtor. So if you have a joint bankruptcy filing with a husband and wife, that's $1,500 of equity in motor vehicles that you can keep in the bankruptcy case. If you're disabled or over 60, that does jump up to $12,500 per person. So it's always important to look at the equity in the motor vehicle. Equity is what you could sell it for and the profit you would make after you've paid off any loans attached to the vehicle. So a lot of my clients have no equity in their cars. Their car might be worth $15,000, but they owe $15,000 or more on that car. Therefore, they have no equity, no profit in that car. So this is often not an issue. But from time to time, I run into somebody who bought a car for cash several years ago, or they paid off their car several years ago, and it's a nice car, and now they have equity in it. So something to keep in mind. Tools of the trade is what you need to do your occupation. This typically applies to self-employed individuals. So right now, if you are self-employed and it's your primary occupation, you can protect it for $30,000 worth of tools in a bankruptcy case, or up to $10,000 if it's not your primary occupation. It's a secondary job you have. Maybe if you're a mechanic and you do mechanics work on the side during the weekends, it's not your primary occupation, but it's a secondary occupation, so you can protect some of those tools you're using to make your money on the side. Next slide here. Oh, sorry, more stuff I can keep. More stuff you can keep is also important to know. Household goods, furniture, appliances, electronics, bedding, pots and pans. You're allowed $3,000 of those per person in the bankruptcy case. And we're not talking replacement value here. We're talking yard sale or auction value here, estate sale value. So for most of my clients, if they really take a look at what they own, most of the stuff they have is older, somewhat dilapidated, and they can't sell it for what they purchased it for. So for a lot of my clients, they can easily put their household goods under a $3,000 value if they take yard sale prices. Then there's also jewelry. Jewelry is at $2,500 per person. Again, that's pawn shop prices or used prices, not what you bought it for. Clothing is at $2,000 a piece. I think Goodwill prices. It's pretty rare for me to have a client who actually has $2,000 worth of used clothing. Retirement funds, IRAs and 401ks. Those are 100% protected. So if you have retirement funds, if you have a para account or other retirement account, those are funds that often clients will liquidate to try to avoid bankruptcy. But it's good to know that that is money they can keep in a bankruptcy case, and so they don't have to liquidate it to get rid of their debts. And then this being March, which is income tax time, refunds are a common hot topic at this moment. So refunds, refunds are typically not protected in a bankruptcy case, but there's two exceptions. If you're getting a tax refund, if there's earned income credit, which you can see on page 2 of your IRS 1040 form, or additional child tax credit, which again is on page 2 of your IRS 1040 form. Those two refunds, those two credits, if they result in a refund, are protected. So I always have to look at my clients' tax returns when they're getting a refund to see if the refund falls under either of these two exceptions. If they do, then they're golden. If they're getting a refund and the refund is not from an earned income credit or additional child tax credit, it is typically best to wait, if possible, until the refund's been received by my client before they file a bankruptcy case. Otherwise, they will have to turn it over to the bankruptcy trustee and not be able to benefit from the refund. Okay, change of topics here. Let's talk about the effects of bankruptcy on your credit score. Again, I've been doing this for a long time. I've seen hundreds and hundreds of credit reports. And the credit reports I pull, at least have the last 10 years or so, come from a company that shows me what my client's current FICO score is and what the score will be a year after we file bankruptcy. So it gives me a projection. And so this slide is based on my experience of reviewing hundreds of credit reports. So generally, if your FICO score is over 650, your FICO score will go down with the bankruptcy. And bankruptcy is a negative item on your credit report. However, if your FICO score is below 650, which is common for a lot of my clients, your credit score will actually go up. And it'll go up within a year after you file bankruptcy. And the reason is that a year after your bankruptcy is done, you will have a year with no late payments reported on your credit report. Creditors have to stop reporting when your bankruptcy is filed. So you'll have 12 months of no negative activity on your credit report. Your FICO score will automatically go up just because of having no negative reporting on your credit report. So it's good to know. Bankruptcy does stay on your credit report for a while, though, as a public record. So Chapter 7 will stay on your credit report for 10 years. Chapter 13 will give you a little break. It stays in your credit report for 6 years. As far as recovery on your credit, it's typically easier to recover on your credit score if you have a Chapter 7 case, because it's a quicker, more cleaner bankruptcy than a Chapter 13, which we'll get into later. So although Chapter 7 does stay on your credit report as a public record for 10 years, typically the recovery time is shorter than a Chapter 13, just because of you getting a clean break from your creditors and starting fresh. Recovery from bankruptcy, like I say here on the slide, is less than 2 years. I have a friend of mine who works, who is a mortgage broker, mortgage lender, mortgage originator. I don't know what her current title is right now, but my clients who have completed a Chapter 7 bankruptcy are able to qualify as a first-time home buyer within 2 to 3 years after their bankruptcy is done. So although the bankruptcy does stay in your credit report for 10 years, it just takes a couple of years and you could be a homeowner if you're not already after your bankruptcy case. So qualifying for bankruptcy. My clients always ask me whether they qualify or not. So to qualify for Chapter 7, it's pretty straightforward. You can't have filed bankruptcy in the last 8 years. And you have to qualify as far as your income goes. There are income qualifications, which we'll go over here in a minute. Chapter 13 to qualify, you can't have a bankruptcy in the last 4 years, but conversely, you must have income to fund your repayment plan. So that'll hopefully make more sense as we go down the line. Qualifying for Chapter 7, to qualify for bankruptcy, you have to compare your gross income to your household size. So this little table shows that. So with a household size of 1, if your gross income is $52,389 or less, you automatically qualify for Chapter 7 bankruptcy relief, so long as there's not been a prior bankruptcy in the last 8 years. If you have a household size of 4, then as long as your gross income, and this is whether you're married or single. If you're married, then we look at both parties' incomes. If you're a single parent or a single individual, we look at just yours. So if you're married with 2 kids, that would make you a household size of 4. If you and your spouse's gross incomes per year is less than $88,796, you qualify for Chapter 7 bankruptcy relief. I have 5 children, so that puts me at a household size of 7. So we would, in my house, we would have to review what my wife's income and my income is by taking this $88,796, adding 3 times $8,100 for each additional person, seeing what that number is. It's going to be $107,000, I think, or $8,000. I'm not a mathematician here. And then looking at our gross income. That being said, my wife and I are both self-employed, and so we would look to see what our adjusted gross income was after business expenses to see if we qualify. So, if that makes sense. And those numbers do change about every 6 months to a year. So this is a floating amount. Also, another thing to talk about here on this qualifying for bankruptcy issue is that when qualifying for bankruptcy, we're looking at the last 6 months of income, not the last year of income. So we take your last 6 months of income and we pretend that's going to be your income going forward by averaging it. A lot of my clients have fluctuating income. For example, I have clients who had really good income for the last 6 months, but then just lost their job or had some other traumatic experience where they're not going to have income going forward. So on paper, they may not qualify for Chapter 7, but their income going forward would qualify them. That's an issue you have to look at if that's your situation. Conversely, I have clients who their last 6 months of income qualify them for Chapter 7 clearly, but they just landed a really good job, and so their income going forward may not qualify them for bankruptcy. So timing and hitting these qualifications can be a huge issue. It's important to talk to your attorney to see, talk to your attorney to see whether you qualify and if timing is an issue that you to be mindful of in preparing your bankruptcy case. I'd say 10% of my cases, timing is important. Okay, typical candidates for Chapter 7, I already touched on this a little bit. There can't be any prior bankruptcies in the last 8 years. Income for the household size needs to be below the median income. on the prior slide. There should be minimal non-exempt assets. That's assets the trustee can take in the Chapter 7 case. So, and then another qualifier for Chapter 7 would be somebody who's trying to save their house from foreclosure or repossession. Chapter 7 is not the right chapter to use to try to save a house or a vehicle from repossession. That's really where Chapter 13 comes into play. So if you're in foreclosure and you think I'll file bankruptcy and save my house, you're probably looking at Chapter 13. If you, on the other hand, if you're going to lose your house to foreclosure and are committed to walking away from it, then you could still file Chapter 7, wipe out your liability on your debts, including that house, and start fresh, since you have no desire, and it's not your goal, to save the house. Typical candidates for Chapter 13. Chapter 13 is different, as we'll get into more here in a minute. If you make too much money to qualify for Chapter 7, you might be a Chapter 13. The number one reason people file Chapter 13 bankruptcy is to stop foreclosure. That's why they put it in bold here on the slide. Stopping foreclosure, number one reason for Chapter 13 bankruptcies. In years past, we've been able to strip off second mortgages. That's becoming less likely because home prices are increasing, but it's still something to look at. If you had a prior bankruptcy in recent years, then Chapter 13 is your only option. So if you filed Chapter 7 in the last 8 years, something happened to cause you need to file a second bankruptcy, Chapter 13 is your option there. I will file Chapter 13s for clients who need to protect co-signers and also protect the non-exempt assets. So if you have a large debt that you promised, that you co-signed with your mother, and you promised to pay that debt, and you want to continue to do so because she either doesn't have the means to pay it, or that's just your solemn oath to her that you pay that debt, then you can file a Chapter 13 and continue to pay that debt and protect mom. So that's one reason to file a bankruptcy case. I also see that with spouses. One spouse will file bankruptcy and the other won't. But the spouse who does file will file a Chapter 13 to protect their co-signer's spouse. Then there's non-exempt assets. So let's say you owned a boat. You don't need a boat here in Colorado. So if you filed bankruptcy and had a boat and you really wanted to keep that boat, your Grandpa Joe left it to you when he died, then you're looking at a Chapter 13 bankruptcy to keep that boat. And that's what I mean here by non-exempt assets that you want to keep. Large priority tax debts. If you owe the IRS or Colorado a bunch of taxes, Chapter 13 may be a good option for you. It allows you to repay those taxes and in a state of protection from the IRS or Colorado and stop any wage garnishments or any levies. Divorce-related debts. If you're in a divorce case and the judge ordered you to pay your spouse's debts as part of the debt settlement, you can discharge that in a Chapter 13. You cannot discharge that in a Chapter 7, but in a Chapter 13 you can. So it's rare, but I do have clients who will file a bankruptcy case after a divorce in order to bankrupt or get out of the obligations that the judge in the divorce case ordered them to fulfill. And there's chronic illness and inadequate insurance. If you're filing a bankruptcy case and you know or have good reason to know that down the road you're going to have another major medical issue, you don't have insurance or you have inadequate insurance and you're going to incur all this new debt, I have put clients with chronic illnesses into a Chapter 13 because it gives them the option of managing that should something awful like that happen. So that's a lot. So Chapter 13s are very useful. They're used in specific circumstances. Again, the majority of bankruptcies are Chapter 7s. Moving on here. Okay, a big important part of the bankruptcy code is the automatic stay. The automatic stay, so when you file a bankruptcy case, if you're being hounded by creditors or threatened with repossession or threatened with foreclosure, or they're going to garnish your wages or take money out of your bank accounts, or the creditors just start calling from 8 a.m. to 8 p.m., when you file a bankruptcy case, all that has to stop. And the reason that has to stop is because of this thing called the automatic stay. The automatic stay is a restraining order that you get against your creditors the moment the bankruptcy case is filed. So, for example, I filed a bankruptcy case Tuesday. Today's a Thursday. I filed a bankruptcy case Tuesday to stop a foreclosure sale in Douglas County on Wednesday. And that foreclosure sale was stopped or stayed the moment that bankruptcy case was filed. And now the homeowners are in Chapter 13 and they can try to keep that home. I've also filed a bankruptcy case to stop vehicle repossessions. And one time I did have a situation where my client's car was being repossessed as we were meeting. We filed his case immediately, and as soon as the case was filed, the repo man had to put the car back down in the parking lot and drive away without the car. So when we say automatic, it is automatic. Same means restraining order, and it is strictly enforced by the bankruptcy court, and it's very powerful and important. That being said, it does not come into place until the case is filed. So just telling a creditor, hey, I'm going to file bankruptcy, that doesn't force them to back off. The only thing that legally forces them to back off is the automatic stay, which comes into play the second your bankruptcy case is filed. So, next slide deals with Chapter 7 process, which I think is a very important slide. I will often hand this out to my clients when they come in for a consultation. So let's just walk through the Chapter 7 process. I've had clients over the years have many different ideas of what a Chapter 7 looks like. I think this slide illustrates it as clearly as I can. So, before any Chapter 7 bankruptcy case could be filed, you have to get the case prepared, naturally. I send my clients an online questionnaire and ask them for other supporting documents. And it's kind of like getting your taxes done. That's got to get done. The other part, though, which is mandatory, is a mandatory pre-bankruptcy credit counseling class. And so it's a one-time session where you meet's probably a loose word, where you talk about or disclose your financial information to a nonprofit credit counselor that's approved by the government, and for them to give you any insight into whether bankruptcy is your best option or not. Typically, this credit counseling costs about $25. It's done 100% online most of the time these days, and at the end of the day, you get a certificate saying you completed it. Most of my clients are able to complete it in about an hour. It is a mandatory step. So once the credit counseling is done, then the case can be filed. Once the case is filed, you're immediately assigned a case number and a court date. That court date being this meeting of creditors over here. And that restraining order, the automatic stay, is in place. That automatic stay protects you from all of your creditors. About 30 days later, after your case is filed, you will go downtown for what we call the meeting of the creditors, or the 341 meeting. I might slip and call it court. Meeting of creditors is an interview you have with the bankruptcy trustee. Remember that triangle I showed you early on with the three parties in bankruptcy? There's the debtor, there's the bankruptcy trustee, and there's the judge. Well, this is the bankruptcy trustee. You go down, if you're in Denver, you go downtown Denver for your interview. It's more like going to the DMV to register your car than it is like going to court. You can usually show up fairly casual. If you're a mechanic and you're covered in grease and whatever, come as you are, it's fine. There's no reason to dress up. And you're there to testify about the accuracy of your paperwork and to make any arrangements to turn over assets to the bankruptcy trustee if there are any to turn over. Most of these interviews take, I don't think I already said this, but most of these interviews take 5 minutes, maybe 10 minutes. The longest part is waiting for your turn. So, like going to the DMV to register your car, sometimes there's a long wait. The time at the actual desk is not very long at all, and then you're out of there. A very similar process. So at this meeting, the bankruptcy trustee is going to determine if there's any money for them to give to your creditors. If there is money, then, or potential money anyway, then they will open up what's called a bankruptcy estate, and that is where they can collect funds from you and disperse it to your creditors. And that really has no time limit on it for them to collect the money. You can get into more detail later. After you have your meeting, though, most bankruptcy cases are no asset bankruptcies, meaning the bankruptcy trustee doesn't collect any money from you at all. So you have your interview, the bankruptcy trustee says there's no money here, and then that issue is done. The next issue is this traffic signal here that represents the 10-day statement, which is where the Department of Justice would review your file to make sure your income qualifies you to be in bankruptcy. Most of my clients get a green light. That's not a problem. Yellow light is when clients have income that's right on the limit or above, and the Department of Justice is not sure whether they should be in bankruptcy or not. And of course, the red light is when the court indicates that they don't qualify to be in bankruptcy, and maybe their case should be converted to Chapter 13 or dismissed. Either way, we get notification from the Department of Justice whether the case is good to go. My goal is always to get a green light. Then, about a month after you have your meeting of creditors, you are required to take a financial management class. Usually that's done with the same company you did this initial pre-bankruptcy credit counseling with, and it costs about $25. It takes 2 hours, and it is mandatory. So you complete the class, you get a certificate, that certificate's filed with the bankruptcy court, and that requirement's finished. And then 2 months after you go downtown for your interview, you get your bankruptcy discharge. The discharge is an order from the court stating that your dischargeable debts are forgiven. So everything is forgiven except for back taxes, student loans, back child support, fines or fees, or fraud, or reaffirmed debts. All right, that's a lot to go over. Hopefully that slide's been helpful to you. Next slide deals with what a Chapter 7 costs. This is a rough sketch. The filing fees to the court are $355. That's what they are right now. That's subject to change. It changes every so often, but it's been $355 now for a little while. So credit reports, my service charge is $35 a piece. I just pass it on to my clients. You get the joint case, it's going to be double that. This table here is for an individual. And there's miscellaneous costs for copying, mileage, etc. The total hard costs for a bankruptcy case are about $405. And then you have attorney's fees, which at this time, looking at about $1,200. It can vary, but that's generally what I charge for a Chapter 7 case. Again, the Chapter 7 bankruptcy takes about 8 hours of time, so you're really getting a pretty good attorney rate there. So $1,200 for my time, and then the grand total's around $1,605, $1,700 depending on your case. So that does have to be paid all up front before your case can be filed, because bankruptcy attorneys are not listed in the things that don't go away in a bankruptcy case. So if I file your bankruptcy case and I have not been paid in full, then I just filed bankruptcy on my attorney's fees, and that's not a very good business model to have. It's doing business to do that. So Chapter 13 is a different animal. I'll quickly go over it. Again, a majority of cases are not Chapter 13s, but this just explains it a little bit differently. So in Chapter 13, you do the case prep, you go to credit counseling, you file the case, we go downtown, and what we're doing in Chapter 13 is we're asking the court to approve a repayment plan, which I'll show you in my next slide. And to get the plan approved, we have a series of court hearings, revisions of the paperwork, a new objection period. Creditors can object. You might have another hearing. We might go through this loop several times in a Chapter 13 case as we're ironing out the issues. Eventually, the bankruptcy plan has no objections to it, and the plan is confirmed. So getting the plan from the filing date to confirmation can take 4 to 6 months in a Chapter 13 case. They are more complex than a Chapter 7. And again, generally filed for people who are trying to save their house from foreclosure or to make too much money to be in Chapter 7. So briefly, in Chapter 13, this is how a Chapter 13 plan works. We divide your debts into 4 different classes. So we have Class 1, which is attorney's fees, back taxes, and back child support. Those things get paid first in a Chapter 13 plan. Next comes any mortgage arrears. In this situation, we have about $12,000 in mortgage arrears built into our plan. The next class, Class 3, is where we have car loans or similar debts. In a Chapter 13 bankruptcy, you can pay off a car loan, and sometimes that's a great benefit to my clients. Other times it's not. In this example, we went ahead and put the car loan in the bankruptcy here. And then Class 4 is everybody else. Everybody else means that. Everybody else. Credit cards, medical bills, loans to your Aunt Martha, some taxes. In this illustration, I put $24,000 here to that class. That's high for a Chapter 13 case. So if I was to redraw this illustration, I'd probably lower that number considerably, something more like $5,000 to $10,000. But it is what it is for this illustration. So what we do is we then what I call simple lawyer math. We add up the attorney's fees, the taxes, the back payments on the house, the car loans, and everybody else. We come up with $55,000. Then there is a fee to the bankruptcy trustee, that's about 10%. So here it's $5,500, and a grand total of $60,500. Most Chapter 13s take 5 years to pay. So in this illustration, we have 60 months here. Divide 60,000 by 60 months, and you get 1,000. $8.33 a month. That's a higher than average payment to a bankruptcy trustee. Most of my clients' payments in Chapter 13, I say, are going to be $300 to $600 a month, depending on the case. I do have clients who have a higher payment than $1,000. I have those are really the exception. But this at least illustrates the mechanics of how a Chapter 13 bankruptcy plan works, what gets paid off in what order, and how you arrive at the number. Every Chapter 13 bankruptcy plan is a snowflake. They're all different and need to be carefully crafted and thought through by your bankruptcy attorney. So, Chapter 13, they're more complex than a 7, so they're often built on an hourly basis because they can be more complex and they're less predictable. So Chapter 13, the costs, the bankruptcy court right now has said a bankruptcy attorney can charge $3,600 for a Chapter 13 case without getting any scrutiny from the bankruptcy court, plus their costs. So if I was to charge $3,600 for a Chapter 13 case plus costs are going to be $600 or so. You're looking at around $4,000, $4,200 for a Chapter 7 case. That's what a Chapter 13 costs. So Chapter 7 is going to cost you, $1,600, $1,700. Chapter 13 is going to cost you $4,000. Chapter 13 will save your house. Chapter 7 won't. The issue, the one difference being in Chapter 13, most bankruptcy attorneys want some money paid up front. That didn't work out too well. And then so you would pay the attorney some fees up front, and the rest would go through the bankruptcy plan. And then, so I can erase that here. There we go. So in this case, some fees are paid up front because there's less than $3,600 built into the plan here, which is typical. You're probably looking at paying $1,500 to $1,800 up front in a Chapter 13 case to the attorney. The rest will be built into your payment plan here. So I'm covering a lot, giving you a lot of information. I don't see that I have any questions. Let me check my dashboard here. No questions at this time. So again, my name is Jesse Aschenberg. I'm the managing attorney of the Bankruptcy Law Professionals of Colorado. We'd love to talk to you more in depth and specifically about your case. It's real simple to get in touch with me. Just shoot me an email or give me a call. 720-493-9733 is my main number, 720-493-9733. And we can talk specifically about your situation and what bankruptcy would look like for you. So I wish you the best. Good luck, and have a great day. Bye-bye.